first webinar of 2022. So we are very pleased to be able to be here today because as everyone involved in this project, we know that this has actually was quite a challenging task to go through this 2 years project that we worked on in partnership with the law firm DLA Piper, who provided us pro bono support for the research, but also many other lawyers and social workers that actually help us reviewing the data and the findings that we actually are going to share with you today. So this is a very wide topic, and where we say where we are at, and we are not really having the ambition to solve all the issue in that webinar today. But our ambition is just to share with you in a conversation style discussion about some ideas about some of the findings that we had in the reports, and we are with our panel of experts of today. So I'm going to first introduce you and to the reports, and mainly the recommendation and a bit of the process that we went through. And then I will actually have the key finding discussed by each of the panelists today. And again, we want this to be very interactive, so please feel free to put your questions in the chat, and we'll be very happy to answer them. And also because we love to know who is there behind the cameras. Unfortunately, we can't be in the same room, but please feel free in the chat to say where you are from and what is your profession, so we know a bit who is today in the room with us and what professions you represent. So a few words, 1, 2, 3, about the Terre des Hommes. Terre des Hommes is a child protection organization. We have offices in several regions in the world, and I'm working for the Europe region. And in terms of programs, we have programs on access to justice, migration, health, and we really work to try to find a way to have the rights of children respected as much as possible. And we really want to have the voices of children heard and to see how children can be empowered throughout their life when they encounter various issues. In the justice program, we work for children in contact with the law, and that is then children that have committed an offense or suspected to have committed an offense, but also children, victims and witnesses in proceedings. That means in criminal proceedings, in civil, but also administrative proceedings. And I'm really, you can actually, my colleague can put some more information about our, let's say, our site to know about our more specific projects in Europe. So I'm going to actually start with a bit of a general context. And again, this is really a little selection of all the issues that we encounter in the area of justice. And this is why we wanted to do this research, is because but among the many challenges that we identified, according to some statistics of the European Union, there would be approximately 1 million children facing criminal justice proceedings each year. That is approximately 12% of the estimated 9 million people that face criminal justice proceedings. We know, and we have evidence from various research and an initiative that are on the field, that children encounter challenges in accessing quality legal assistance or skilled lawyers that really can have a child-friendly approach and understand what children need when they are involved in proceedings. We know also that child offenders and victims are more vulnerable in the justice system, that processes are not really what we call child-friendly or child-centered. And so we have children that are from ethnic minorities, children from with disabilities, children from the LGBTQI+ community, to quote some of them, have encountered particular issues, and in several occasions their rights are not really upheld as they should be. Children face lengthy legal proceedings, which means for them in the life of an 18-year-old, a few months is actually equivalent for an adult of several years, and can really impact their development and their integration into the society. Children that are victims also, or children that are offenders, they can be re-victimized or victimized by being involved in multiple interviews, having to repeat your story all over again to various professionals in the process, has an impact on the child itself. And so this actually can have a negative impact on their life. And also a big one, also when we consulted recently with children, is the access to information, understanding the rights that children have and how they can access information when they're involved suddenly with a police officer or probation, who is sharing information with them, what kind of information, and is the information made in a language that is actually can be understood by the children themselves. So these are just to mention a few of the challenges that have been identified. And this is where, with this report, we wanted to actually conduct a research that was to highlight a bit the gaps between the implementation of European standards, in particular the two key directives of the European Union, the Procedural Rights Directive and the Victim Rights Directive, but not only, because we also look at other legislations, including the legislation from the Council of Europe. And also, what are the challenges that do children face when they're in contact with the law in Europe? So for this, we drafted a questionnaire that actually had over 100 questions that were more linked to actually a bit the legal and policy framework. So to really have a picture of what would happen in Europe. This was done absolutely on a volunteer basis. So we would like to excuse ourselves already for if you would see that there's some data that needs to be updated, because we know for a fact that already what we are publishing probably will need to already be updated, because this is a topic that moves quite a lot with time. We had actually, so we made a request with the lawyers from DLA Piper, helped us to gather, collect data, and we have 23 countries in Europe that participated and 19 responses received on this questionnaire that helped us to elaborate 18 fact sheets. So I'm going to share you the link afterwards, so you can go, and please feel free to go and look at the 18 country fact sheet with some core information about the situation of children in contact with the law in Europe. We conducted this research from 2019 to 2021. And I mentioned already the partnership, and we structured our results around these 5 themes about the overview of the child justice system. So we look at particularly children in conflict with the law. We looked at children, victims and witnesses of crime. We look at who are the key stakeholders and experts that are involved into making the situation of children better, and a specific focus on status offences and the child justice system. And today, Dr. Stephanie Rapp will say a few words about that. So here is just to give you a map of these other countries. It included Russia. We actually had responses from Russia. So if you are interested in data from Russia, but this you see covered quite a bit. So countries from the European Union, but not only, also countries outside the European Union. So just to mention some of the key recommendations, and I invite you to go and read the report. It's not a very lengthy report, it's very visual, but this is really to link it also with the recent key strategies on the rights of the child from the European Commission, the Council of Europe strategy on the rights of the child that is also going to be renewed this year. We actually structured, based on the data collected, our recommendation around 4 main themes. First, it's really highlighting that we need to build the skills of professionals that work with children in criminal proceedings. There is a need to really reinforce the training programs if they exist, or to set them up if they don't exist. To really involve young people, we need to hear the children and young people's voices to actually be able to build proper, more solid training programs. It is very key to partner with professional organizations, National Bar Association, judges' schools, or other professional schools, so that it's not that we work in silo, but we actually really work in an interprofessional way. We need to look at opportunities given by innovation, and there are innovations such as digital innovation, but also other way of working to really include also children's views into this, and to better understand the needs and rights of child victims. We also recommended that we need to create child-centered policies and legislative frameworks, that there is some need for renewed, let's say, specialized legislation for children. We have some findings around that. The question of the minimum age of criminal responsibility keeps popping up every time. Working towards ending child imprisonments, to swiftly move towards better, more efficient alternatives to detention, and to find a way at least find a way in Europe to decriminalize status offences. And also to see that for young adults, maybe to see how we could extend the benefits of the child justice legislation, and to ensure that all the safeguards of the EU directive are actually implemented. We also recommended here, and I'm curious to hear about the researchers that are with us today about this, that we really need to invest in a robust monitoring of the situation of children. And here's always data about, do we really know about how many? I mean, there's the quantitative data, there's the qualitative data. And we see when we talk about equal access to justice, I mean, how many children, what type of situation, and we really notice how much we are lacking the data to really back up and create also the evidence for the policies that we would like to move forward. And of course, this must be linked to measurable indicators. And last but not least, to improve the knowledge of professionals about the needs of children in criminal proceedings. And this goes through child-led advocacy. This is about knowledge about free legal assistance, what it means in practice, better communication material, needs assessment that are done in a multidisciplinary way, and of course, all questions related to detention and the follow-up of the global study on children deprived of liberty. So these really are a few of the recommendations. So in order to maybe further dig in the key findings, so here's a link to the report. So it's at the top, you go on the Child Hub, or if you Google in the title of this report, you actually will have access to it. So it's a synthesis report together with 18 fact sheets that are done with the same template, where you can actually also have linked to the specific legislations that are applied in each of the countries. So now, after this brief presentation, I want to really warmly welcome our panel. So we have here with us Ingrid Breid from the European Commission, Koosje Peterses, a practitioner in the Netherlands. We have Dr. Astrid Podsialowski from the Fundamental Rights Agency of the European Union. We have Zsuzsanna Rutai, an expert on child rights that has the pleasure to join us today, and Dr. Stephanie Rapp, a researcher at Amsterdam University. So I'm going to now give the floor to Ingrid Breid to actually address our first question. So Ingrid Breid, you're a lawyer by formation, and you have been working in the European Commission for several years. You are currently team leader in DG Justice, in charge of procedural rights of suspect and accused person in criminal proceedings. You are responsible for, you have played a very key role on the directive, the 2016-800 directive on procedural safeguard for children. You know it very well. And you have been involved in the drafting, the negotiation of this directive, and you are now also involved in monitoring its implementation by the member states. So we have, you see, in this report, in the research that we conducted, we have some findings that I just want to mention to you, but I have then a question to know, like, is it already outdated if we think of today's pandemic situation and the new challenges that came about? So for instance, we see that according to this, again, the countries that responded to the questionnaire, we could think that there would be 100% of child-specific legislation. We are still 5%, let's say, is not much, that not yet have child-specific legislation. If you look at the position of the children's child-specific disposition at constitutional level, we actually have 3/4 of countries that have disposition provisions in the constitutions, but not all of them. Is that actually important to have it at the constitutional level? If you look at the specialization of professionals who work in the justice system for children, we could have assumed that maybe in our region, we would have actually have 100%, or we would have hoped for 100% of professionals that are specialized, police, prosecutor, judges. And we actually found out that, for instance, lawyers, only 6 out of 18, so a third of lawyers are actually really specialized. And the maximum will be 11 out of 18 for judges and social workers. So if we are far from reaching actually 100% of specialized professionals in the field, so does it affect actually the specialization of the area of children's rights? So now we have these figures, but the question to you is that, do you think that the pandemic, the COVID-19 pandemic, actually affects this type of data? And also, if we think of the procedural safeguards, as you have been working closely on the directive, what does this pandemic teach us about respecting procedural safeguards for children in a digital environment? The floor is yours, Ingrid.
Many thanks, Mariama, and thank you also for the invitation to speak here. I'm very pleased to be with you this afternoon, and I was very carefully listening to the presentation of your report and all the findings you have brought forward. I think that's a very interesting piece of work, and very helpful also for us in the context of monitoring the implementation of EU law which exists in this area. As you mentioned already, there are about 1 million children in the European Union coming into contact with police and judiciary every year. And the children are particularly vulnerable in criminal proceedings due to their young age and immaturity. So very often they have difficulties to understand the law and their rights. And therefore, I think we all agree that they need our highest possible protection. And it's against this background also that the European Union has adopted in 2016 the directive on procedural safeguards for children who are suspects and accused persons in criminal proceedings. This directive is particularly important as it provides a very comprehensive protection of children at all stages of the criminal proceedings. And I would really like to underline that it goes from the very moment, the very beginning, when a child becomes a suspect or accused person, until the conviction of a child. And it's based on international standards such as the UN Convention on the Rights of the Child and the guidelines of the Council of Europe. I just mentioned a few elements of this directive, which I consider particularly important. And that's first, the directive supports the effective participation by a child in criminal proceedings. So it's very important that the child has prompt information appropriate to the age and the understanding of the child about the rights and also the nature of the proceedings. So the child must understand what's going on, what's happening. And I think that's very important, yes, even essential for criminal proceedings. In addition to the child, the directive provides also that information, or the same information, needs to be provided to the holders of parental responsibilities, so to the parents. And in some cases where there is a conflict of interest or the parents are not available for whatever reason, another appropriate adult should be informed about the rights. Another important element is the assistance by a lawyer, the assistance and access of a child to a lawyer, and in serious and more complex cases, the mandatory assistance by a lawyer. So, for example, no prison sentence shall be imposed if the child has not been assisted by a lawyer, at least during the hearing before the court. And member states should also ensure that legal aid is provided in case there are not sufficient substantial financial means. The children should also be subject to an individual assessment. It's one of the key elements of the directive as well, in order to ensure the specific needs of children concerning protection, education, training, and social integration are taken into account. And I will come back to this a bit later in my intervention when we really talk about COVID and the impact of COVID. The directive also provides for safeguards in case of deprivation of liberty and the use of alternative measures to detention. So pre-trial detention should be, of course, for the shortest possible time, a measure of last resort, and can only be imposed on the basis of a reasoned decision and subject to judicial review by a court. In case a child is detained, children should be separated from adults, also a very important element of the directive, and they should have right to specific safeguards and specific protection in detention centers, so education and training programs to foster their reintegration into society, measures to ensure their health, physical and mental development, etc. And one element I would also like to underline in the context of the directive, that's the training and the training for judges, prosecutors, detention staff, and also for lawyers to the extent possible. So if you ask me today if this directive is already outdated, I am certainly harshly contesting this. I think it's but it entered into application in June 2019. Of course, a lot of things have happened in the meantime, but I think all the main safeguards we need today are there. But it's of course very important that this piece of legislation is implemented. So it's implemented in law, in the national legal systems by the member states. And I think there is still a lot to do. And it also needs to be applied in practice by the practitioners. And there also, I think, still work needs to be done. Just a few words on the implementation. As I said, the directive had to be transposed by member states in June 2019. A number of member states at the time had not implemented the directive, so the Commission launched infringement proceedings against 8 member states. In the meantime, all member states have notified, and we are currently looking into the legal transposition, so in the legal systems of the member states, and making a completeness and conformity check. A report on the implementation of the directive will normally also be published by the European Commission in the course of this year. And already at this place, I would also like to say that my colleague Astrid and Fra is also working on the implementation of the directive in a number of member states, and I'm sure that Astrid will speak about this a bit later. Now on impact of COVID and digitalization, the COVID pandemic had, of course, a very serious impact on the national judicial systems, on the court's abilities to work, implying in many cases their partial closure or limitations to the access to court premises. But not only the access to the courts was restricted, but also access to lawyers, for example, the communication of suspects and accused with the legal counsels. Also, there was an impact on detention. Staff and prisoners are concerned about their health. Prisoners suffer from the lack of activities and visits, which makes it, of course, a challenge to keep staff motivated and also to to have more problems in prisons. This is, of course, important for, let's say, adult suspects and accused, but even more important and difficult for children who are even more vulnerable in detention. Member states and the national legal systems took steps to mitigate the impact of the COVID pandemic in the functioning of courts and ensure access to justice through the adaptation of procedural rules, and in particular the use of digital technologies. And it's very important to underline that also in times of COVID, the procedural rights of suspects and accused persons need to be respected in order to ensure a fair trial and fair proceedings. Also, the Procedural Rights Directives, I'm not speaking only of the children directives, but in general provide for certain exceptional derogations in very specific circumstances. However, those derogations should be interpreted very restrictively, and the competent authorities may not employ these derogations on a large scale. Member states are, of course, and the competent authorities also encouraged to use as much as possible video and audio conferencing tools for the purpose of remote interpretation, for example, or other measures. But there is not only the video and audio conferencing, but there are also other measures like glass shields in order to, for example, to facilitate the communication with lawyers or other protection possibilities. A few words still on the digitalization. Digitalization has, on the one hand, and COVID has showed that very clearly, a lot of advantages to overcome closed courts, for example, or the possibility not to see a lawyer. However, it has, of course, also a lot of disadvantages, and really a balance needs to be found on the one hand between the use of digital tools and on the other hand also the sufficient respect of the rights of suspects and accused persons, and notably also of children. The Commission has in this context also adopted a package of legislation in December last year on digitalization, and also a proposal for a regulation on digitalization of cross-border judicial cooperation and access to justice in criminal proceedings. And we have included also provisions on the hearing through video conferencing or other distance communication technology in criminal proceedings, on procedural safeguards, such as the respect of confidentiality of communication between suspects and accused persons and their lawyers, and on the hearing of a child. So the parent shall be informed, and the authority needs to take into account, when deciding on hearing a child via video conferencing, the best interests of the child. So the work still continues. And still, I would like to end now my short intervention with the impact of COVID on two measures in particular. So that's the individual assessment, where COVID certainly had a considerable impact on the application in practice, on the need, for example, to ensure the timeliness of an individual assessment if court services are closed or restricted. It's very difficult to find the right persons to work with the qualified personnel which should be involved to come up with an individual assessment, to ensure the multidisciplinary approach, to involve all the different services becomes much more complicated in this context. Also, the involvement of parents might become more complicated, and of course also the involvement of the child himself or herself gets more difficult. And so we see that COVID has a very strong impact on the reality, on the application of the safeguards which are there, which are provided for by the directive and should be provided in all the legal systems of the member states. But the application in practice becomes more difficult. And there, I think we can still work around also to find solutions, how this could be better applied. Another example is, for example, the access to lawyers, where also here we could see that COVID had a strong impact during lockdowns to find a lawyer, to get in contact with a lawyer, to ensure also the communication between suspects and accused, in particular children, with a lawyer during video conferences, for example. And for children, I think it's even more difficult to have that, let's say, communication basis with a lawyer and to understand what's going on in the proceedings if it's, for example, a hearing via video conference.
Okay.
So
I think that
I will stop with this here, and I'm looking forward to any questions or to the discussion in the panel, and to see also experiences from other panelists in this context.
Thank you very much. It was very important to have you speaking first, because you really also frame and it really follows and bounces back nicely with the questions that I will now, I think, follow up with Kosha, because of her practitioner point of view. And now you are also launching a few hints to see indeed that we are happy to hear that the legislation is not outdated, and there are possibility to adapt our rules, our procedures to challenges such as the COVID pandemic put us in, and the different example that you have given about how to use the digital technology and tools. I see that there has been a question in the chat I'm going to ask you, but also wanted to ask, because I'm sure that many of us here are interested to know about where would we be able to access this example of, let's say, tools, and are there communication done by the European Commission? Can we access on the site? So what you were just mentioning about ways to deal and to apply, let's say, the safeguards in this, let's say, digital environment. So is there a place that we can refer our audience to? And then the second question, and I'm wondering if this will be information that is for the report. There is curiosity about which are the 8 countries, the 8 member states that are under infringement procedures for the directive. Is this information that can be shared now, or is it something we will see in the report? And then I will actually move to Kosha, because she can answer a bit some more practical related questions.
Yeah, thank you for these questions. First of all, with regard to the infringement proceedings, those were the infringement proceedings I mentioned were the infringement proceedings for non-communication launched against 8 member states in 2019. Meaning that those member states had not informed the Commission in time about the implementation of the directive into national systems. In the meantime, all member states have notified transposition measures, and we're currently looking into the conformity and whether all these measures are complete as well. But as this compliance check is still ongoing, I cannot go into a detail, and we will certainly provide some further information in the implementation report, which is due for this year. We are, after the finalization of this compliance check in the course of this year, we will also, or the Commission, if it considers it appropriate, to launch further infringement proceedings for non-conformity, or in case it comes up that some member states have notified complete transposition, but nevertheless certain provisions are lacking. Then as regards digitalization, as I said, the Commission has published in 1st of December last year a package of several proposals related to digitalization, including also this proposal for a regulation on cross-border judicial cooperation. There are also a lot of press releases and communications in this context, which are available on the website of DG Justice. And in this context, also before, there were already a number of Commission communications on this subject.
Okay, thank you. So I invite everyone to go on the DG Justice website to follow up on this. And we're certainly looking forward for the 2022 report about the directive. I see in the chat that we actually have quite a few professions represented, so I'm sure everyone will be very much interested. So I want to pick on something you said about needs assessment, and I'm looking at you now, Kosher, because I think there is a nice link between what Ingrid has just presented. So it gives us the framework of also the safeguards, a bit of the challenges that we're encountering with using, let's say, adjusting to this digital environment. And you as a practitioner, so you have been working for almost 20 years as a youth and criminal lawyer in The Hague in the Netherlands. Since 2018, you work as a substitute judge in the Court of Rotterdam, mainly in the youth courts. You are a board member of the Association of Youth Lawyers in the Netherlands, and you frequently join expert meetings on in the child justice fields, and you also occasionally give lectures in youth criminal law. So from your experience, how do you see, if we take, for instance, one example about the assessing the needs and the challenges that Ingrid just brought forward, how, do you think we are equipped enough? Because there are recommendations, but are we really equipped enough? And from a practitioner point of view, and the clients, let's say, of lawyers, the children, are they actually satisfied with the way things are working today?
Thank you, Mariama, for this nice introduction and for the invitation for this webinar about this very interesting topic. And a lot was already brought up by Ingrid. And I think we were all working in the same field, and I think we see, and I see from my point of view that we're trying to bring up everything on a higher level, but a lot can be improved, even in a rich country as the Netherlands. And for example, the directive really emphasizes on the training and the skills of the professionals who work with children. I think that's a very important part, because you have to, if you work in the child justice area, about the legislation, but it's maybe even more important how to work with the children, how to get to make really contact with the children. So to get to know what the specific child you see in front of you at that moment, what are his or her special needs, and how do you get to know those needs, and then how you work, how can you work from there and improve their lives. So the directive, it's of course a very good advantage, it's there, but we still have to breathe life in all the directives and make them also working in practice. And I think, from a lawyer's point of view, we always see try to see everything from both sides, and from our profession we are criticals. So I think a lot of people were thinking about all the disadvantages of the digital tools. But then COVID-19 came and gave us a lot of challenges, and in of course everywhere, but especially also in the procedures, and the courts were closed and the police stations were closed, and people couldn't visit each other. So we really needed those digital tools. And I think from there we saw we use them a lot more in practice, and you see the advantages and the disadvantages of them. For example, if you talk with, if you go as a lawyer, you go to a suspect, a minor suspect in the police station. Normally you go there and visit the child and have a talk with the child, just the two of you, to get to know, to build a trustful relation, to try to build a trustful relationship, which of course takes time, and you have to see each other and to feel each other's energy. But when the pandemic started, especially in the start of the pandemic, everybody was really trying to have as less contact as possible. So a lot of first contact was done by phone calls or by video calling, which makes it much harder to really see what kind of child you have in front of you. And also, if you attend a hearing by phone, it's, of course, you miss a big part of the the energy in the room between people. And so it makes it less. You have a lot of more or less contact than you should have. And on the other hand, it's more efficient. So you can enter in the digital way the hearing much faster. There is no traveling time, for example, not for the parents, not for the lawyer. So there are also advantages on that side.
Yeah, Kosher, I'm a bit puzzled, because at the same time, I forgot to mention one of the findings in this report is that, we are starting with, especially on this pandemic, we didn't start with a system that was perfect, far from it, right? We managed all the challenges we listed. There are many more. And individual assessment and needs assessment, multidisciplinary, is really one of the challenges. And we are now a few organizations, I see even some are present here today, that work with EC funding to actually explain more what we mean with assessment. So at the same time, we have, in terms of finding that, for instance, 22% of the countries do not have actually really the safeguards of individual assessment that are really incorporated in national legislation. I find this very low. So I'm thinking, so how, on top of that, switching to a digital environment, we can then really ensure that these assessments can be actually conducted, knowing that when judges make decisions that don't necessarily refer to, that don't base, we have 3 out of 4 sentences that are based on an actual social inquiry report. That means that there are still some sentences that are not based on this report. So will it be that this digital environment, you said that it's more efficient, but is it really from the point of view of children, knowing that children are more comfortable online? And we have heard cases that they actually, because of that screen, it made them actually a bit more comfortable to talk to their professionals. But have you experienced this in the Netherlands, for instance?
Sorry, have I experienced?
When you say more efficient, and the fact of this, that children being more comfortable in the online environment, but can we say that then the actual needs assessment or the individual assessment of the child are done according to all the requirements that needs to be in place, knowing that we are online?
I think it's can be on both sides, like, because children can be more comfortable if they are online and they don't have the stress of traveling and things like that. So it might, for some children, it might be easier to be interrogated by professionals and tell their story and their lives and their needs. But on the other hand, I think we should be careful that it should not be too easy to do it that way, because you miss a lot of things around the child. And you don't know if you talk to the child online, who is in the room. Does he feel safe when he's talking? Things like that. But I don't know if that's the answer on the question. Because I think
no, it is. I mean, it's really an open question. And I also want to raise this question for the other panelists, but also for the audience here. I see that I saw there are some psychologists, social workers, and maybe don't hesitate to share in the chat a bit about your own experience of that switching to the online environment. And does it improve the quality of the assessment or decrease it?
I have one example just a few weeks ago of a child who had to go. It's not exactly the individual assessment, but he needed to go to court, and it was a very child with a lot of special needs, and he didn't want to go to court, and he didn't want to talk about the cases, and also he had to travel like 2.5 hours from his youth institution to the court. But then I talked with him about being there on a screen, and that for him it was a big solution. So in the end, he had a very good court session, while normally he was very emotional, and in earlier court sessions he was a lot of emotion, and he couldn't tell a story. And now he had a very good court session, maybe also because of the fact that sometimes the technical tools were not working very well, so we had to stop again, and so that the court session took a lot of more time than normal, and a lot of breaks because of the technical. Well, then the screen had to be changed or things like that. But in a case like that from him, he felt much more free to tell about his situation.
Okay, but so
we had a lot of time to use this tool on a good way. So that I think that's very important.
Yeah, so I think it's indeed essential to hear that also, that shift there are, because we are thinking of maybe ethical risk because of the digital environment, but also we see that in some cases it actually came as a positive solution, as the example that you are sharing, that it's in a way, it's as if it makes the child feels more trustful in the environment because maybe of that distance that is created. So that will be interesting to hear and to compare in various countries what is people's experience. So maybe now, if it's okay, Kosher, I want to go to Dr. Astrid Podsialowski and to hear a bit maybe some reflections of what you have heard so far. And then I also have a question for you, more related to, let's say, the data collection. First of all, I want to say welcome, Astrid. You are a focal point and project manager on the rights of the child in the European Union Agency for Fundamental Rights. The agency is providing evidence-based advice to decision makers on European and national level. Your area of expertise include child-friendly justice, child participation, child poverty, discrimination and social inequalities, migration and integration, and research methodologies. You are a social and cross-cultural psychologist by education, and you have previously held academic research and teaching positions in Europe, as well as New Zealand and the USA. So we are very much interested to hear from what Kosher has just shared and Ingrid from their own perspective about this, maybe some challenges related to the online environment. But the specific question to you will be, looking and hearing the recommendations that were shared today, and we discuss individual assessments, the issues of accessing legal assistance, the necessity to have better alternative being implemented. How, in your opinion, can all of this be enhanced with data collection mechanisms? Is it really beneficial? Let's say, is it beneficial to have better data collection mechanism for children in contact with the law in Europe today?
Introduction and all your important questions. I mean, spontaneously, as you see from what you were talking about, my background, researcher, of course, key. So that's a very brief answer. Individual assessment, but I think I will do this when I finish, because I first want to refer to the data question, because then I will say do infra, and also why I think I can say a bit about individual assessment as well. Because I'd like to start with your recommendation, and like when you look at all your recommendations, essential to have data and conduct. Monitoring is clear. I mean, when you talk about monitoring, we want to assess the impact of certain interventions and measures, and this indicators, quantitative indicators in many cases. So we want, for example, who's in conflict with the law. So also you mentioned of children are particular at risk.
Sorry, Astrid, just to mention, because I think we have some sound, it breaks down a bit, and I see that I'm not the only one, that the sound breaks a little bit from your end.
The problem is my internet connection seems to be very unstable, and I was trying already to improve it and haven't managed. I think it's actually my agency. It's not my home connection.
Now it's working. So hopefully.
So please, you know, always lift your hand, and then I make a short break, because I haven't found, I tried for the last half an hour to find out what the problem is. And I actually really think it's connected to my workplace connection and not to my home.
Now it seems to work again.
Okay.
So please go ahead.
So please raise your hand, because then I make a break and then repeat again. Yeah. So I had said that I wanted to start with your recommendations, and that I would say that all your recommendations require good data collection. So when you talk about monitoring, you want to assess the impact of interventions, of measures, and we can only do this if we know the actual situation of children by, for example, having clear quantitative indicators. So which group of children are at risk, statistics disaggregated by different groups of children, different age groups of children. How do concrete proceedings look like? What procedural safeguards are used, are implemented? What are likely outcomes? What measures are put in place? And then the important part is always like to monitor the situation over time. So only if we have systematic and research, we can say, okay, what impact do certain measures have, like alternatives to detention, diversion measures, restorative justice measures, on the situation, on development, on changes for children who are in conflict with the law. So for this type of information, we have different data sources, and it's also important to talk to people concerned. And also when we talk about skills and knowledge of professionals, this needs to be based on sound knowledge of what works and what doesn't. And also to learn from children themselves, to really hear what experience they have done, what helped them, what didn't help them. And here we should not only talk about certain accounts or voices or discussions, but go beyond into a systematic form of data collection, fieldwork research, for example. And then I think we can only talk about child-centered policy and programs, so that we really also have systematically analyzed what the experience by children are. So this leads me a bit to what we try to do in the agency. As you were saying, we provide, one of our mandates is to provide evidence-based advice, particularly on the implementation of new legislation and policies. We have been doing field research. Okay, you know, sometimes it works when so I think now it's connected again.
Yeah, now it's good.
Okay, I always have to click on my workplace connection, then it gets better. Thanks. Yeah, so what we have been doing at FRA is to conduct fieldwork research with children and professionals, more qualitative based type, to learn from their experiences and when children are involved in proceedings. Our first reports in 2015, and actually we can see quite some progress. For example, when it comes to children to be heard, also to be protected. Actually, there is more guidance existing, there is more training existing. There have been actually quite some the commission from the states to develop tools. But we still need to ensure that the procedural safeguards are put in place, like based on the Victims Directive, the Procedural Safeguards Directive. Which then again leads me now to Ingrid's presentation, because we're actually very happy that we were asked by the Commission to feed into their implementation report on the Procedural Safeguards Directive, which is due this year. So the reports are not published yet, but we have conducted all interviews and analyzed the data, the interviews with children and professionals. So I want to say a few things about some findings that we have, and particularly they relate to access to a lawyer, to individual assessment, right to information. So we do have actually quite some good accounts of experiences with how lawyers or also judges inform children and how they listen to them. And we also see, again, this makes such a huge difference for the participation of children. It makes such a difference whether they have this experience that somebody took the time, respected them, tried to understand their background, informed them properly of how kind of they contribute to the proceeding then. And the children also throughout always appreciate support, including parental support, but of course also really social support by juvenile court assistants, social assistants. This is always throughout the time appreciated a lot, also in addition to be assisted by a specialized lawyer. But we must say that we have also very negative accounts of how professionals behave towards children. We have also very clear, concrete examples of violence, of not being taken serious. And so again, it stresses this high importance, I think, also of kind of multidisciplinary cooperation to also a bit monitor the behavior of professionals, but of course training. And for all professionals who are in contact with children on child development, on raising awareness of their rights, but also of kind of the perspective children may have towards a proceeding, and to understand also their living situation better and support them better. And some critical counts also are, for example, that we have a lot of questionings at the police that take place without a lawyer present. We do often have accounts that children lack the information about their rights. They usually know some basic rights, but not all the rights that have been outlined in the Procedural Safeguards Directive, and particularly when it comes to first contact with authorities. Lawyers are then very crucial for children in the course of the proceeding to better understand what's going on, to understand the conduct of proceedings and their rights. Particularly at first contact is particularly problematic. And as you may have noticed, I said that also there are a lot of questionings without lawyers present. And when the lawyers are the ones who kind of have a crucial role in informing children, there's already this big gap. So, so here, this is again based on all the data we've been having over the years. This right to information, appropriate information is such a key issue. And one aspect also we noticed being particularly critical is the individual assessment. And the children in our cases that we interviewed, the online question wasn't such a big question. The meetings with professionals were normally in person. The digitalization question or the COVID question was more relevant when they detention about being in contact with peers and parents. The individual assessments were usually done in person. But many children did not have individual assessments. Also in quite a few member states, it's not obligatory. Or they did have assessments which they weren't always aware about. They were in contact with workers, but they kind of did not understand that this needs a this, and that this will have also kind of, okay, so I click again. Good. Good, it says connected again. I try again. Sorry for this. Yeah, so with the individual assessment question, there is the children we know from the gatekeepers via whom we also contacted the children that sometimes they have done individual assessments, but the proceedings then moved forward. And of these type of assessments, or then it was a different profession didn't appreciate that the profession they only saw once was talking. Said I've talked already a lot to some professionals, and why shall I repeat this? So we're not aware about the importance of these assessments. And I must say we have also among like this 50 kids that we interviewed, there were 19 kids who had language difficulties, be it like their local language was not their mother tongue, or they had also some other speech difficulties. And out of those, for example, 7 didn't get an individual assessment, and out of the ones who got an individual assessment, actually, really only 3 kids got translators or interpreters during the proceedings. So the effect was very low. Also in interviews, children were telling us that they could not really properly read the information letters, and but that nobody really seemed to have noticed, and they were also kind of pretending they understood, but then told us in the interviews they, to be honest, they didn't understand. So this whole area of how individual assessments are done and what impact they have, I think is a very critical part, and really shows also the difficulty of having equal access for all children to proceedings. So this is the specific comment to individual assessments and some hints into the findings that we see.
Yes, so you really, in French you say you bring water to my mouth. It means like I can't wait to read the reports. And I think we can all, and also a bit reassured, but I think it's the wrong word to say that. It's to say that indeed the findings that you are sharing now, those are just, I guess, a few hints, and there will be more detail in the reports with what we have found with our research over the past 2 years, but also when we consulted over 40 children 2 years ago almost in anticipation of the EU strategy on the rights of the child. And it really came that children were saying all of this. We lack access to information. We don't understand the information that is being shared with us. So I find it quite concerning that that children somehow, it feels a bit of being dragged into a system that's going so fast that they cannot really follow necessarily the pace. So how can we make this at the speed also of the child, by still and also being at the speed of the system, let's say. So thinking about this when we mean about child-centered or child-friendly justice. And so I think this finding will really highlight what we need to work on as organizations in partnership. And you mentioned multidisciplinarity, that is key, that this is not a matter of one sector. Is actually the matter of various sectors around the child. When we talk about justice, it's also about protection, health, psychology, mental health. And so we need to see how we can make it indeed efficient in order to give sense to this safeguard. So I really want to thank you, Astrid, for sharing these insights and the fact that you also consulted children, that the FRA consulted with children in the process is really key. And it's also concerning to hear about this institutional violence that keeps going, especially if you think that some of the children have been victims of violence already, and you add an additional layer of violence to this. So this also gives us food for reflection into in what direction do we need to orient our work more efficiently. So because it's all very interesting and the time is running, and I think that maybe I would like to take what you have said and bring actually the topic, but zoom a little bit on one aspect that you addressed and that was addressed before, which is legal assistance. And I would like Zsuzsanna Rutai, that is with us today, independent consultant working in the field of children's rights protection, to actually say a few words, focusing a bit more on legal assistance. But Zsuzsanna, also feel free to comment on what you have heard so far from the colleagues here today. So you have worked at the Secretariat of the Lanzarote Committee and the Minority Ombudsman of Hungary. You are currently supporting the Parliamentary Assembly to involve children in their work and the Slovenian authorities to mainstream child participation in their new Barnahus. So you are involved as a national expert in the Clear Rights Project Enhancing Legal Assistance for Children in Europe, which is coordinated by Terre des Hommes and in partnership with the other organization, PILNET, Defense for Children, and other organizations. And so it would be quite interesting for you to share with us a bit this question of legal assistance, but also when we think of legal assistance for children that we refer in contact with the law, that means both categories. Then we wanted to look to hear your thoughts about this aspect of this. Why is it important to approach both categories of children, not just children in conflict with the law, but also victims when we talk about legal assistance? And do you think that this concept of children in contact with the law is easily translated into other languages? Because this is also a concept that was developed in English, let's say. And in order for you to answer, I wanted just to share one, let's say, one or two findings from our reports, and that is basically that we found out that that in the majority of cases, so let's say 68% of cases, there was no specialized training for lawyers. So this highlights the fact that there's a low number of really specialized lawyers that are representing children. And only 6 countries could state that they had specialized lawyers. And the free legal assistance in 74% of the country, that means really 3/4 of the country, was actually conducted by NGOs. So is that a good thing or not? I'm putting the question to you, but also maybe to see why is it important to talk about these 2 categories of children. Thank you, Rojana.
Thank you very much, Mariama, and thank you also for the invitation. Yes, replying to your question, I would like to start a little bit far, let's say. Do you hear me well? It's working, right? Okay. Yes, so I think it's important to consider that when we talk about children in contact with law as a concept in English, then we refer to children who get into touch with the justice system in various ways in relation to family matters, in administration, immigration procedures, as well as victim or witness of a crime or as an alleged perpetrator of a criminal offense. I'm going to focus on criminal justice here, but this is already an artificial concept because the standards ensuring the rights of child victims and the rights of children suspected or accused of committing crimes have always been developing separately with few exceptions. One of these exceptions is the Council of Europe Guidelines on Child-Friendly Justice, which is the first holistic approach to children in contact with law. It has general and specific elements of the different proceedings, but it aims to ensure that all rights of children are fully respected with due consideration to the child's level of maturity and understanding and to the circumstances of the case. This report on children in contact with law in Europe also brings forward this issue. It analyzes the safeguards applied in cases of children who have allegedly committed an offense and in cases of child victims and witnesses in criminal proceedings separately based on the Procedural Rights Directive and the Victims' Rights Directive, as it was already explained. And if you compare the 2 tables, we can see that for example, the right to individual assessment or the right to privacy are ensured in case of child victims in more countries than in case of child suspects or accused. But there are also similarities as well. The right to have decisions based on the best interest of the child is the least common safeguard for both child victims and child offenders. However, the standard with regard to the right to legal assistance in all phases of the criminal procedure is in place in all countries covered by the report. I want to focus more on this. So the Council of Europe Guidelines declares that children should be considered as fully fledged clients with their own rights, and the lawyers representing children should bring forward the opinion of the child. And this applies to any kind of procedure. The recent general comment of the UN Committee on the Rights of the Child on child justice also made it clear that the right to legal representation is a minimum guarantee in the criminal justice system for all persons, and this should equally apply to children. At the same time, if we look at, for example, the Barnahus model and its adaptations in different countries through laws and bylaws, the child victim's right to lawyer and its practical implications are not articulated well. The Barnahus is a child-centered model where the child victim of sexual abuse receives adequate support and protection thanks to a multidisciplinary and multi-agency approach. The right to information and the right to be heard is one of the Barnahus quality standards, but it does not refer to legal assistance, for example. In order to ensure the validity of the children's statement as evidence gained at the forensic interview happening at the Barnahus, the role and the access of the defense lawyer is elaborated on, but this is not necessarily the case for the victim's lawyer. It can further complicate the case if the Barnahus can accept child offenders as well for the interview. The right to legal assistance has several elements. The rights holders need to be aware of it. They need to have access to a certified legal professional, and this professional needs to be trained to work in that particular field of law with that specific group of clients. Exposure to the criminal justice system is traumatizing for children, irrespective of the reason it happens, whether they fell victim of a crime or infringed the law. Sometimes the same child is a perpetrator of a crime, but the victim of another crime. As you already mentioned that your report find that only in 32% of the cases there were specialized training provided for lawyers representing children. It was not clear from the report, but I guess here they were talking about the defense lawyers working with child offenders. The other number you mentioned about free child-friendly legal assistance, I think this is also very crucial because this shows that it is more likely to find an experienced professional at these organizations, civil society organizations. And I think this report proved that it would be time to talk about legal assistance to children in contact with law, embrace and combine the different safeguards developed for child victims and children suspected or accused of committing crimes. And I think this might have a positive effect on the training of legal professionals as well, who needs to be equipped with knowledge and tools to work with vulnerable and traumatized children as a clients, either victims or suspected or accused clients.
Okay, thank you, Zsuzsanna. I think it was key for us to listen to this, because it's true that when we talk about child justice, and we often do a bit of a short cut towards criminal proceedings, we're thinking of the needs of child offenders, children that have committed or suspect to have committed an offense, or we indeed think about violence, but we don't necessarily think about this intersectionality, about the fact that a child that has committed an offense also can be a victim in parallel proceedings or in the past. So that actually it's very almost abstract to make this different categories. So I'm thinking, because I'm also aware of the time, and maybe we could also have Stephanie to comment a bit on this, maybe to bounce a bit on what you have been sharing with us, Zsuzsanna, and also if others from the panel would like to then react to it. I think I would like to maybe also bring the two more statistics findings from the report to Stephanie, so we make sure we have time, and already to see if maybe we'll be running 5 minutes late, but please bear with us, because we would like to make sure that everyone stays with us till the end of Stephanie's presentation. So, Dr. Stephanie Rapp, you are assistant professor at the program group Forensic Child and Youth Care. You hold a master's degree in pedagogical science that you obtained in 2006 and criminology in 2008 from Utrecht University in the Netherlands. In 2013, you defended your PhD dissertation that is entitled The Participation of Juvenile Defenders in the Youth Courts, a comparative study of juvenile justice procedures in Europe at Utrecht University. This involved a legal and empirical comparative study on youth justice system in Europe. So I am sure that you were very attentive to when Astrid especially was sharing about the initial finding of this research, and also maybe the comments from Zuzana and Kosher about the feedback from children, as you are quite experienced also in child participation. So I want to just share my screen to show you these two, let's say, two data that, I would like to raise your attention on, because there are two topics that are a bit less attractive topics in a way, but so key essentials, and it's so less attractive that we all try to work on it, and it's still difficult to find solutions and harmonization. Can we talk about harmonization on this topic when we talk about the minimum age of criminal responsibility in Europe? And you see from our reports, we see that we are wondering, so if children have committed an offense below the age of criminal responsibility, we wanted to know, can they be prosecuted or not for the offense once they are above? So let's say 12-year-olds, you committed an act before 12 years old, but you are prosecuted after 12 years old. And in fact, we found out that still 16% of countries still can be, so of children, of the countries that responded, indeed, children can be prosecuted for the offense, even though it was below the age of criminal responsibility. So this for us, meaning we wanted to hear your opinion about that particular finding. And another finding that is more related to status offenses. You know, one of those offenses that actually you only get a sanction for the child for an act, an offense that is committed that is not considered an offense when you're an adult. Those are status offenses. And here, sorry, the screen maybe is a bit small to be able to read it. But this actually shows that the possession of tobacco, of alcohol, the fact to actually be beyond parental control, the begging, breaching social behavior and norms, still today, there are actually children that are, when they're in this situation, they're still dealt with by the justice sector. So does it mean that you can actually end up in prison because you have committed a status offense? Is that fair? I mean, shouldn't we talk about putting an end of decriminalizing status offenses in Europe? So I'm keen to hear about what you have to say about that. Thank you.
Thank you, Mariama, for inviting me to this webinar, and also the presentation of your very interesting report, and also for the kind introduction. First, to go back to the issue of the minimum age of criminal responsibility, which is, I think, a highly debated subject among many countries, and which also is very much politically loaded subject to define at which age children should be able to take a responsibility for certain acts that they commit. On the other hand, when we look at the Children's Rights Convention, we also see that children are given a dynamic legal position. We say that children mature and that their capacities develop along with their age. So this is a little bit of a contradiction between stating rigid age limits in the law and also trying to put in some flexibility where children mature at a different pace. On the other hand, I think in criminal justice, it is very important that the minimum age also is a tool that gives legal certainty to children, because it means that you know that from a certain age you can be held criminally responsible, but when you are below that age, you cannot be convicted of a crime as you were a juvenile or an adult, for example. However, countries apply many different definitions to minimum age, and also have multiple minimum ages in their systems. And I think that also came out of your research. that I think in around 7 countries there are multiple minimum ages applying. And that usually is the case when a lower minimum age is applied for very serious offences. This is, for example, the case in Ireland, which is not included in this study, but the minimum age there is 12. But when young people are suspected of committing a very serious offence, such as murder or homicide, then they can be prosecuted from the age of 10. And that is because of the seriousness of the offence. I think a similar method also applies in France, for example, where they say, for example, that they do not really have a strict minimum age. And that, for example, below the age of 10, they do not apply sanctions, but only protective and educational measures. And only when children are 13 or older, really criminal sanctions are applied. So they make such a hybrid system, so to say. Therefore, I think it's also very difficult sometimes to really research this topic and to really find out what an age limit means. And when children can actually be punished in the system, or when there are more welfare or protection measures applied, which sometimes can also be very harsh on children because they're still put in an institution, for example, although it might not be called a juvenile prison, for example. So this is to give a little bit of context around the issue of age limits. And I think it's important to remember that the Committee on the Rights of the Child has stated in General Comment number 24 that they say that it is preferable to have one age limit and to not give too much discretion to judges or other professionals, for example, to apply criminal responsibility at different ages, for example, really to give children the procedural protection also. With regard to the second topic of status offences, which already explained that these are, for example, truancy or running away from home. And I think in your report, you can also see that different reactions are given to that. Not only criminal justice reactions, but also child protection or social welfare reactions. But in some countries, this is criminalized as well. And that can have adverse effects on the life of children. For example, when this results in a criminal record for the child, which can have very negative consequences for their education and then later work, for example. It can also have a stigmatizing effect on the child when they are criminalized for doing these behaviors, because then they are labeled as offenders in the system, and they might also use this as a way of life and continuing also their criminal or antisocial behavior, and going on the wrong path, so to say. This labeling and stigmatizing effect, I think, is something we should all try to prevent. Therefore, welfare measures or more preventive or diversionary measures could be more well suited in case of status offenses. On the other hand, I would like to also say that some of these behaviors might also be risk factors or indicators that there's something not going well in the life of the child, and may also are indicators of later delinquent behavior. So it's important to take this seriously. And use it to take action, maybe to intervene in the family, also together with parents, and try to prevent further offending from happening at a later stage of the life of the child. But on the other hand, it should also be not forgotten that children who are arrested, for example, and have to stay at a police station and who are dealt with in this formal youth justice system, that this can be very traumatizing also for young people. And as we heard before, many instances they lack information about what is happening, and this can have a profound impact on how they experience this, and maybe have more negative consequences than solving anything. So these are my first responses to your research.
Yes, thank you. Also interesting to highlight this need for proper collaboration between the child protection and the child justice systems, right? Because with minimum age, we're talking about a response that maybe would be more likely a child protection response, but there are still maybe some justice matters that relate to it. So indeed, in countries, you're giving some examples, also in France, or where there sometimes is one judge that is dealing with child protection and justice matters. Sometimes it's separate, but at the end, is not a file of that goes from one desk to another. It's the life of a child, and as you say, it can have lots of consequences. So again, multidisciplinarity seems to be key here to understand and to monitor the situation of the child, to address maybe what you're indicating here as the risk factors, these indicators maybe of potential future maybe harmful behaviors. We have here in the chat Astrid that shared an interesting resource for the audience about a member state publication on the minimum ages across EU member states. So I invite people to go and look into this. And also we have a question, you sort of responded to it, but we have a question about if there are special facilities for children that have committed a crime when they were below the age, or when they are below the age of criminal responsibility. But I guess, Stephanie, this depends on the country in which facilities there are. Are they actually put in a facility or not?
I think if they are considered to be criminally responsible and a suspect in a case, they are just treated the same way as other young people until 18 in a youth justice institution. But if they are more seen as children who are in need of care because they have shown these behaviors, then they might be more involved in a protection system. That can also be that they are placed in a residential institution, for example, with other young people who have various protection needs and problems. So that really depends. But of course, I think one of the other speakers also highlighted that it is not allowed to place children in places where also adults are detained, for example. So adults and children need to be separated, although that might sometimes be difficult when young people age out, for example, become older than 18, but were convicted when they are still younger than 18. So sometimes they're still mixed, but I think the general idea is that these children are still seen as young people who have committed a crime, although formerly they might have been below the age of criminal responsibility. I hope that answers the question.
Yes, absolutely. And I'm just wondering, before we close, if any of the panelists would like to have a quick reaction of what Stephanie just presented, or if it's fine, and then I will wrap up and this session. So take the microphone or raise your hand if you have something to say. But if not, I will actually want to share that indeed we in the report. So again, I invite people to go and read the report. There are, as Stephanie mentioned, also indeed minimum ages. So we actually, the fact sheet are done in a way that you can see per country, which is actually the minimum age of detention, of the criminal responsibility, etc. So you can actually have an interesting comparative element there. And indeed, there is lots of work still that needs to be done. As you say, it's also indeed a quite political matter, because also it brings the competences of key ministries in this case. So maybe, since there is no other comments, I would like to wrap up, but to say, indeed, you mentioned, how can we ensure legal certainty for children? Is that actually possible? Today we discuss, I would say quite briefly, but with some examples about the challenges that today children in contact with the law face in Europe. And I think it opens, I don't know for you, but for me, quite more questions and ideas about how to further, cooperate with the child protection sector, how to dig in more in the multidisciplinarity, and how to actually define better what we mean by child-centered and child-friendly in itself, and how we can bring maybe theoretical concept into really practical implementation, so that the professionals that are working directly with children really can understand what it means to communicate in a child-friendly way, to understand their needs, to follow, to monitor their situation, and so that the child doesn't, as we were saying, go a bit from one place to another. So in this case, my colleague also shared the report here, the link again in the chat. I would like to thank you all very, very much. The panelists especially, and we had to change some dates. There were some challenges in the organization for today, but we managed, so I'm very glad. I would like to thank also our partner that couldn't be with us today, but DLA Piper, that is the law firm that helped us with the pro bono lawyers to collect some of this information, and that we are also looking forward to hear from you, so you can reach out to us. My colleague Marcos can put here our email address if you want more information, or follow us on LinkedIn or on the social media. We also have a TDH Europe page, because we would like, as a second step, and this we would call for further volunteer brains, let's say, to look at the practical implementation also of this. So now we look a bit at the legal policy framework, some example, but to see now, okay, in practice, because again, this data is already almost outdated in a sense, and we need to see how we can further look into the situation and find more just and adapted measures for the children. So I would like to thank you very much, and stay connected. And there's here a last poll that our colleague Vesna has put, if it was interesting for you. And it's good for us to keep track of the webinars and the format, and don't hesitate to email back also a feedback if you have, so we can always see how to improve our service and exchange ideas. So thank you very much, everyone, and have a good rest of the day. Bye-bye.